Judgment in an appeal, Teal Assurance Company Limited against W.R. Berkley Insurance Europe Limited.
Lord Mance will give the judgment.
This appeal concerns a programme of insurance arranged by a firm of architects and engineers incorporated in Delaware, USA, Black & Veatch Corporation. Under the programme, Black & Veatch agreed to bear a $10 million United States dollars retention together with a deductible per claim. After that, Black & Veatch arranged insurance cover in layers. The first layer was arranged with Lexington for $5 million. Then there were 3 PI tower policies for a further total of $55 million cover, and on top of them was a top and drop policy for a yet further $10 million cover. The 3 PI tower policies and the top and drop policy were all placed by Black & Veatch with its captive insurance company, Teal, which is the appellant. Teal reinsured them with various different reinsurers. The top and drop layer was reinsured by Teal with the Respondents. All the layers provide worldwide cover for Black & Veatch except the top and drop layer, which excludes United States and Canadian claims made by third parties against Black & Veatch. Black & Veatch has received 27 claims from third parties. 4 of these are of substantial size, considerably exceeding the total available cover. 2 of the 4 are United States and Canadian claims totaling over $200 million. The other 2 non-United States Canadian claims total some $42 million. The question on this appeal is whether Black & Veatch and Teal, its associate captive insurance company, can arrange payments under Black & Veatch's insurance program in such a way that the United States and Canadian claims are met out of the lower layers, so far as the limits on those layers will allow. This would leave the top and drop cover available to cover a further $10 million US dollars worth of non-US Canadian claims. The alternative, for which the respondent reinsurers contend, is that claims impact the insurance program from the bottom up in the order in which claims by third parties against Black & Veatch are ascertained, that is, by agreement, judgment, or award as against Black & Veatch, or in the case of expenses incurred by Black & Veatch in respect of claims, in the order in which Black & Veatch incurs such expenses. On this basis, advocated by the respondents, it appears that the claims remaining after exhaustion of the Lexington policy and the PI tower policies could well be United States Canadian claims which would be excluded from cover under the top and drop policy. Teal argues that its position is correct both in general principle, since a party can always perform a contract in the way which best suits it, and under the specific terms of the policies which Lexington and it issued to Black & Veatch. The judge and the Court of Appeal disagreed. Teal now appeals. The Supreme Court, in a judgment given by myself, dismisses Teal's appeal. As a matter of general principle, a third-party liability insurance is exhausted as and when and to the extent that claims are ascertained as against the insured. Pending actual payment of such claims by the insurer does not retain some continuing parallel liability for other claims, and there is therefore no insurance cover against which the insured can choose to present later claims instead of those which are first ascertained as against it. The position could be different if the insured abandoned any intention to look to insurers for the earlier ascertained claims, but that is not the case here. Here the insured wishes simply to adjust the priority of claims made against it. As to the specific clauses relied upon by Teal in the Lexington and the PI tower policies and top and drop policy, their effect upon a true construction of these insurances is simply to determine the time when insurers have to pay, not the identity of the claims in respect of which insurers have to pay. As and when the Lexington cover is exhausted by claims ascertained against Black & Veatch, first each of the PI tower policies in turn, and finally the top and drop policy, drop down to become the primary insurance cover. although the obligation of each layer of insurers actually to disburse the policy indemnity is, under the specific excess policy terms, postponed until after the underlying insurers have paid admitted liability or been held liable. This appeal is therefore dismissed with costs.